Discussant. I now call on Professor LANDO to take the floor.
Thank you very much, Judge. One of the main issues that I had when preparing some remarks for today was to understand exactly what the role of a discussant was supposed to be. And as I was preparing my remarks, I quickly realized that I was going to be a reviewer number 2. Now, I will be mostly focusing my remarks on what the jurisprudence of ICLS has been doing in relation to maritime delimitation so far, and in that way I will be building on what my fellow panelists have been doing. Now, I'm very well aware that we have 4 ICLS judges, not less than 4, I believe, in attendance today, so anything that I might say is very much intended in a constructive manner. Now, I will address 2 questions over the next more or less 15 minutes. The first one is, first of all, what has ICLS progressively developed in relation to maritime delimitation? And in doing so, I will concentrate very much on the continental shelf beyond 200 nautical miles. So in that sense, my talk is not ultra-virus, probably. And the second point is whether ICLS should progressively develop. Now, of course, I will be concentrating on ICLS, but some of my remarks can also apply to other international courts and tribunals, the ICJ included. As to my first question, what has ICLS progressively developed? Now, we'll make 3 points in relation to that one. The first one concerns the applicability of the 3-stage approach and the development of the 3-stage approach, especially in the Bangladesh-Myanmar case. Now, that approach has been, so to speak, taken by ICLS after it had been developed for a number of years by the International Court of Justice, and we could say consolidated in the 2009 judgment in the case between Romania and Ukraine concerning the limitation in the Black Sea. Now, interestingly to me, ICLS calls that approach not so much a 3-stage approach, or at least that is not how it calls it in the Bangladesh-Myanmar decision. It calls it the equidistance relevant circumstances approach. The problem of that particular nomenclature, though, is that I believe it muddles the waters a little bit. The reality is that, to me, any method, 3-stage approach included, could potentially satisfy this more general approach called equidistance relevant circumstances. And that might depend actually on the relationship that we see equidistance having to relevant circumstances. Is one applying before the other, for example? This is something that has already arisen in the jurisprudence of the ICJ and ICLS, already in the 2007 Nicaragua-Honduras case, and then also in Bangladesh-Myanmar. Because instead of applying, especially in the territorial sea, instead of applying the equidistance method first, so to draw an equidistance line and then eventually adjust it based on special circumstances in the territorial sea and then further in accordance with relevant circumstances beyond 200 nautical miles and within 200 nautical miles, ICLS has actually done the opposite, and the ICJ as well. They have looked at the map of the territorial sea and have said, well, there seem to be special circumstances not to apply equidistance, so we'll do something different. So in Nicaragua, Honduras, there was an angle bisector that was drawn and then simply extended all the way beyond 12 nautical miles. And in Bangladesh, Myanmar, ultimately we ended up with an equidistance line, but again, we started with the second step of the methodology before. So again, I believe that there is a bit of lack of clarity in respect of what exactly that particular approach means, although there is an expectation, perhaps, in the scholarly community, amongst counsel, and perhaps among some of the judges, that equidistance relevant circumstances really means a 3-stage approach, at least when it comes to the limitation beyond 12 nautical miles. Now, the second point that I would like to make goes on specifically to zero in on the limitation beyond 200 nautical miles. Now, ICLS had a golden opportunity in the 2012 Bangladesh-Myanmar case to set the tone for what was going to happen in relation to the limitation beyond 200 nautical miles. Now, I feel that to some extent that opportunity has slightly been missed. Now, why has that opportunity been missed? Well, what ICLS did was simply to extend the line that was drawn within 200 nautical miles beyond 200 nautical miles. And of course, Professor MAGNÚSSON told us everything about that we need to know. Now, of course, one can ask, what can ICLS practically do when you come to the point when you have already done your delimitation exercise within 200 nautical miles and you have to decide what to do beyond 200 nautical miles? After all, beyond is further away, and you need to deal with the line that has already been established within, including, for example, where the line beyond 200 nautical miles will start. Now, ICLS has done something interesting to me, which is, first of all, delimit within 200 nautical miles, including adjusting the line within 200 nautical miles. And then he had to go on and deal with what happened beyond 200 nautical miles. It's interesting to me, though, that the Bangladesh India Tribunal did something slightly different. Instead of completing the exercise of delimitation within 200 nautical miles, it simply stopped at the point of adjustment. It traced the equidistance line, considered relevant circumstances, but refrained from adjusting just yet. Then he went on to considering what would happen beyond 200 nautical miles, tracing the equidistance line, considering relevant circumstances, and then adjusting the entire line within and beyond as a single exercise. Now, that perhaps seems to be a slightly better approach because at least it gives the possibility to a tribunal to adjust everything in one go and not being stuck with a line within 200 nautical miles when maybe beyond 200 nautical miles there may be other circumstances that would warrant a different approach, or perhaps adjusting the line in a slightly different way. Now, the other question, of course, and that has been touched on by the panelists as well, is how exactly are we supposed to delimit beyond 200 nautical miles? The approach so far has been to apply the three-stage approach. The problem is that there is at least an argument that can be made that beyond 200 nautical miles there are other circumstances that should be taken into account. Geology, geomorphology, the existence of discontinuities in the continental shelf, in a way what Bangladesh used to call the most natural prolongation argument, or perhaps what can happen between opposite states, which is that there might be a furrow or a trench that can divide two tectonic plates, and that could be, potentially, a boundary beyond 200 nautical miles. Now, again, ICLS had an opportunity to say something about those criteria, to set the pace or the tone about what was going to happen in relation to those criteria, but it didn't really do anything of the sort. And I suppose that the reason why it did so, it was because it was being very pragmatic about what it was doing and the kind of case it had in front of it. The Bay of Bengal was, as we all know, or is, a place that has a very peculiar geological nature to it. We all know that there is entitlement. There are no major discontinuities if you discount the most natural prolongation that Bangladesh was trying to argue on the basis of. So ICLS simply didn't do what it did not have to do, which is, I suppose, a golden rule when you sit in an international court or tribunal. The third point that I would like to approach is the relationship between delimitation and delineation. And on this one, I have to say, I am very much on the other side of the fence by reference to Professor MAGNÚSSON, because I have at least written something which was very much taking the opposite view, which is that, in my view anyway, it is very problematic to delimit a maritime boundary without knowing exactly where the outer limit of the continental shelf actually is. I can buy into the idea that UNCLOS doesn't say anything about the relationship between the two different processes. But I believe there are very good reasons why one should refrain, at least in a number of cases, refrain from delimiting unless you know exactly where the boundary between the high seas, well, the international seabed area, and the continental shelf actually lies. Now, there are 2 points I would like to make in that respect. The first one, and it's something that has been touched on again by the panelists, concerns this concept of the single continental shelf. Now, ICLS made a big thing, I believe, in the Bangladesh-Myanmar case of this idea of the single continental shelf based on Article 76 and Article 83 as well of the Convention. Now, to me, that particular concept is not entirely persuasive. I'm not saying there is no merit to it, but I'm saying that there are some arguments that can be taken into account to say that sometimes there might be situations in which the continental shelf is not unique in international law. And there are 2 points especially in that respect. First of all, there are some provisions in the Convention, one specifically, and I'm thinking of Article 82 of UNCLOS, that apply only to the area that is beyond 200 nautical miles. Article 82 concerns the contributions that have to be made to the International Seabed Authority for a certain number of years after a state starts exploring and exploiting the continental shelf beyond 200 nautical miles. And the other one, and I believe that this is something which is relevant to the Nicaragua-Colombia case and the 2 questions that will be heard in a month's time in The Hague, concerns the relationship between the EEZ and the continental shelf beyond 200 nautical miles, or the continental shelf in general, actually. Now, the general idea, and I suppose that the gray areas also give us this general indication is that there can be a distinction of jurisdiction. So one state has jurisdiction over what happens in the water column, instead another state can have jurisdiction over what happens in the seabed and the subsoil. But what if, for example, we were to say that the exclusive economic zone, upon being proclaimed, upon being declared, subsumes the continental shelf within 200 nautical miles? Now that, to me, at least if I were counsel for Colombia, that is exactly what I would be arguing, or at least trying to argue, but alas, I am not. So I believe that that's one of those arguments that can be made, based especially on the practice of states in relation to maritime delimitation treaties. Now, whereas at the beginning of maritime delimitation treaties, and I'm thinking about treaties being concluded in the 50s, in the 60s, in the 70s, when we did not have a concept of the EEZ yet, states used to delimit only, of course, the continental shelf. But the question to me is, what has been happening exactly after all that time? What happened after the EEZ became part of customary international law and part of UNCLOS? Well, states have been doing something interesting, which is to delimit all-purpose boundaries, which means they cut across every single maritime zone, or they have been delimiting what they call exclusive economic zone boundaries. There is no reference whatsoever in the vast majority of treaties concluded from the 80s all the way to date. There is no reference to the continental shelf as a separate entity from the exclusive economic zone. Now, I don't know exactly how much one can make of that, but at least I think that that gives a hook, gives a basis to argue that the EEZ can, in fact, incorporate the regime of the continental shelf within 200 nautical miles upon being declared. Now, that, of course, means that we are left with a new maritime zone, which is simply the continental shelf beyond 200 nautical miles. Now, there is a danger, in a way, to extending the view of ICLOS in Bangladesh, Myanmar, because unfortunately, ICLOS made an unqualified statement in that decision, that ICLOS simply could exercise jurisdiction to the limit beyond 200 nautical miles because of this idea of the single continental shelf. And the ICJ seemed actually to take up this unqualified statement in its 2016 judgment on preliminary objections in Nicaragua, Colombia. But what is interesting to me, anyway, is that later on, the ICJ actually seemed to qualify that statement. Only a year later, in the 2017 preliminary objections judgment in Somalia, Kenya, the ICJ seemed to backtrack because it said that the ICJ will go on and delimit beyond 200 nautical miles, even though there is no knowledge as to where the outer limit of the continental shelf is, in appropriate circumstances. Now, the question, of course, is to understand what exactly these appropriate circumstances are, and I don't believe the ICJ has had a chance exactly of saying what those might be. But we might infer from the case of Somalia, Kenya especially, that those appropriate circumstances might be when the states, for example, agree that the court can go on and delimit, there is no objection to it. But I suppose that the idea that I'm trying to put to you here is that there shouldn't be really an unqualified co-optation of the statement being made in Bangladesh, Myanmar into the jurisprudence of other international courts and tribunals. I feel that it should be qualified by the particular circumstances that are prevailing in each particular case, as, for example, the ICJ seemed to suggest, at least in its 2017 decision in Somalia, Kenya. I will leave now my first question and go on to my second one, which is whether international courts and tribunals, ICLOS included, should progressively develop the law when it comes to maritime delimitation, speaking in particular as to the delimitation method in this particular case. Now, first of all, of course, the question is, what can international courts and tribunals conceivably do when they're given very little to work with? Now, Article 74 and 83, we all know in the Convention, are vague, irremediably so. They only mandate an equitable solution, and whatever that might mean is very much in the eye of the beholders. So in a way, we might say what states left it to international courts and tribunals to deal with. That is as much as we know, and that is what international courts and tribunals should be doing. Of course, the question is also, why should these international courts and tribunals go on developing the law? Well, I suppose that there is something to say about the inconsistency, a lack of clarity of the law concerning maritime delimitation at the time, at least, when UNCLOS was being negotiated and adopted. At the time, everything was about equitable principles, and each case was seen as a unique situation that required a unique solution. But the thing is, many states did not like that sort of situation. They were campaigning to have equidistance codified into the convention, And perhaps because of that, international courts and tribunals thought they had some sort of mandate to try and go back to this idea of equidistance that had been so dismissed in the North Sea continental shelf cases. I suppose there is also something to say about just our mindset as lawyers, though. We do like neat things, we like consistency, we like to put order in what we do, and I suppose that having a standard approach that applies throughout all cases, the three-stage approach now, speaks to the mindset that we have and this endeavor to try and make things a bit more neat. The problem is that the international law of maritime delimitation really isn't one of those situations in which it is simple to find consistency because of the specificity and uniqueness, if you want, of each and every case. I believe it was Herschel Lauterbach that used to say that international law is the vanishing point of the law. And he used to say also that international humanitarian law is at the vanishing point of international law. Well, when it comes to adjusting the provisional equidistance line, as Professor MIRON said earlier on, I believe we are really very much at the vanishing point of the law of maritime delimitation. We don't really know what is going on. So trying to be neat and consistent in relation to it can be really challenging and difficult. Of course, there might be also reasons, really, for international courts and tribunals not to go on and developing in a very creative way the law of maritime delimitation in relation to the approach that we use. Well, first of all, and you forgive me for taking a very state-centric view of international law here, but at least to me, or the way that I was taught, is that rules of international law are very much made by states. Whether it's treaty, whether it's custom, that is what the basis of everything is. And it's very much an orthodox position. And the problem, I suppose, also of developing the law by international courts and tribunals when it comes to delimitation is that I do not think that we have quite figured out, as a scholarly community, what exactly is the position of judicial decisions within the system of sources of international law. And I believe that the International Law Commission is about to embark upon a project on that particular topic, which at least signals that there is something that we really do not know about that yet. The other problem that I see, I suppose, is a practical one. Well, the more we try to fit every case into the same standard approach, the more I believe we create opportunities, chances for the approach not to be consistent, exactly because of the specificity and uniqueness of every case. At the end of the day, the final question really that I think we should be asking ourselves is, well, what do states think? What is the approach of states to the law of maritime delimitation as developed to date? Now, that's not very easy to give an answer to this particular question. There are a number of materials that we can look at. One of them, of course, is pleadings before international courts and tribunals. And of course, the interesting thing about those pleadings is that states try to apply or to distinguish the three-stage approach in different cases, across different cases. I suppose that there is also perhaps a drive to try and cater to what an international court or tribunal is expecting the states to plead, or how the international court or tribunal expects those states to plead. So I do not think that we can lay too much emphasis on what pleadings actually say. The most interesting thing would be, of course, to try and understand how the limitation treaties that have been concluded since the two- or three-stage approach has become the prevailing methodology of maritime delimitation, how those treaties have been negotiated. Do states behind closed doors consider the two- and three-stage approach, for example, when negotiating these treaties? Now, we have some indications, very few, unfortunately. Some indications, and one of them comes from the agreement that was negotiated between Norway and Russia in 2010, because we have a statement being made in the Parliament of Norway by some negotiator or by an MP, I don't quite remember, but the idea is that there is a statement very clearly that says that in negotiating that agreement, Norway and Russia took into account the methodology as developed by international courts and tribunals in 3 stages. And the other one, the other statement that we know is concerning a treaty to which Barbados, I believe, is a party. But that, unfortunately, is not any statement that was made in a public forum. It's a statement that was reported without a source, because I believe that there was some confidentiality duty going on there, without a source in the 7th or 8th volume of Chania and Alexander's series on international maritime boundaries, the one that came out most recently. It's a bit difficult to know exactly what states think because we have issues of access, of course, and states are not going to say all too easily what exactly goes on behind closed doors. So that would be the conclusion of my remarks for today. I would like to thank you all for for indulging me throughout the presentation now. Thank you again to my panelists, and I will pass the floor back to Judge Al-KHASAWNEH. Thank you very much.
Thank you very much, Professor. Now I give the floor to Professor Lee.
Yeah, thank you very much to Professor's excellent presentations, and in addition to Professor Lando's good perception about the role of the maritime delimitation. First of all, I have to express my thanks to the Korean Ministry of Foreign Affairs and the ICLS and the Korean Society of International Law. I'm highly honored to be here, because as you know, all panelists, presenters, and discussants are all maritime delimitation people. Yeah, actually, Bjarni's speech recall my Edinburgh life, and then I remember he was very unique PhD student because he was highly involved in the 2012 Bay of Bengal case. So I remember he had several meetings with the people for Bangladesh, and he emailed the people. Yeah, so a very unique student. Yeah, and Professor MIRON was involved in the 2017 Ghana Cote d'Ivoire case. So, and then, Professor Lando, published his good book, entitled Maritime Delimitation and Judicial Process. So, I'm highly honored. Maritime delimitation is a very interesting subject for scholars, because actually, from the 1969 North Continental Shelf cases of the International Court of Justice, we have more than 20 cases. And then the rules governing maritime delimitation, especially the delimitation of continental shelf and the delimitation of EEZ, actually the rules are very vague, absurd, and abstract. To achieve an equitable solution. And so this subject is very interesting and a little bit difficult to understand. I think, surprisingly and naturally, actually last night I chose some paragraphs among the 2012 Bay of Bengal case and 2017 Ghana Cote d'Ivoire case decided by the ICLS and special chamber of the ICLS. But actually, the two presenters, all covered, covered. Actually, that means we are looking to the same, paragraphs or same direction regarding maritime delimitation. So I think I have to add to something in with the presenters and discussant statements. I think the ICLS has made a significant contribution to the development of the law of the maritime delimitation. Actually, as you know, only two cases were decided by the ICLS and special chamber. And one more case is coming soon between Mauritius and the Maldives. However, one good point to be noted is that I think just regarding the 2012 Bay of Bengal case, Professor LANDO pointed out the three-stage methodology was established by the ICJ in the 2009 Blacks case, and just after the case, Bay of Bengal case. Bay of Bengal case incorporated the three-stage methodology. That means actually the ICLS incorporated, adopted another court methodology. Actually, after since the 2012 Bay of Bengal case, the ICJ and the ICLS have made cross-reference to the statement, important statements decided by each other. For example, three-stage methodology, the relationship between delimitation and delineation, and the role of the CLCS and and the delimitation of the continental shelf beyond 200 nautical miles. But I would like to just point out more cases just before 2012 Bay of Bengal case. I mean the ICJ cases. Actually, as I said, the rule governing maritime delimitation is abstract to achieve an equitable solution, and so there were some tension, conflict between predictability and flexibility. The first presenter of this conference, yesterday, Professor Yoshifumi Tanaka, he emphasized the balance between predictability and flexibility on the law of the maritime delimitation. Actually, for me, I more relied on the concept of flexibility, because the concept of relevant circumstances is a key player in maritime delimitation. Anyway, actually, when international courts and tribunals started to establish, just as Professor MIRON pointed out, aqueous judiciary. I think Professor Yoshifumi Tanaka said the 1993 Yamain case started, but we have to focus on 2001 Qatar Bahrain case and 2002 Nigeria Cameroon case. And just for your reference, the 2002 Nigeria Cameroon case, the first case for an international court to apply Article 74, Paragraph 1, and Article 83, Paragraph 1 of the UNCLOS. So just 1 year before the 2002 Niger Cameroon case, that means there's Qatar Bahrain case. The case applied the customary international law, and the case, the ICJ said the equidistance and special circumstance rule is closely interrelated to equitable principles and relevant circumstance rule. That means the assimilation of the two rules. And then in 2002, the ICJ, when applying the UNCLOS, actually the terms have been changed, not rule, but method. So equidistance and special circumstance method is very similar to equitable principles and relevant circumstance method. Since the case actually for international courts and tribunals, the term special circumstances disappeared. And then actually, in 2009, the court, International Court of Justice, established three-stage methodology. Yeah, as you know, in the first stage, the court established a provisional line, generally a provisional equidistance line. And then in the second stage, to adjust that provisional line, the court has to take into account relevant circumstances, generally geographical factors. And then thirdly, the third stage is entitled, called disproportionality test. But actually, I would like to focus on hidden stage. Yeah, that is called stage 0. Yeah, at the stage 0, some scholars call the stage 0, hidden stage, the identification of a relevant cost or a relevant area. So in 2012, the ICLS just adopted the last case methodology. And then for the 2012 Beom Bengal case, as professors noted, the concept of delimitation should be separated from, naturally, but the concept of delineation. And that means the role of the CLCS should be distinct. And then I would like to focus on the concept of a single continental shelf. Actually, the professors already noted. However, because of the concept of single continental shelf, actually we conveniently differentiated inner continental shelf from outer continental shelf. However, because of the single continental shelf, actually we can apply the same approach to the delimitation of the continental shelf within and beyond 200 nautical miles. So, and then actually because of the concept of single continental shelf, as Professor MIRON pointed out, some scholars said some countries, some states, including China, Korea, and Nicaragua, intentionally encroached upon the inner continental shelf of the other state. However, actually, just my perception, but in exactly on 14th March 2012, the ICLS made a decision about the Bay of Bengal case, adopting the concept of single continental shelf. And then after that, China, Korea, and Nicaragua, after that, they all made their submissions to the CLCS based upon the concept of single continental shelf. And so I don't think that's intentional encroachment. Because of the concept of single continental shelf, actually, we cannot give any priority between inner and outer continental shelf. And then, about 2017 Ghana Cote d'Ivoire case, actually, already Professor Mignon pointed out, but just this is my question. According to paragraph 591-992, this means that relevant judgment gives one entitlement priority over the other. Such a decision accordingly has a constitutive nature and cannot be qualified as merely declaratory. I already, Professor Mignon, read. Just my question is, this is incompatible with the 1969 North Sea continental shelf cases. I think the ICJ differentiated the concept of apportionment from the concept of delimitation. So, actually, the ICJ in the 1969 North Sea contention cases supported the concept of the being declaratory. I think. So when I firstly read the 2017 Ghana Cote d'Ivoire case, I really had this question about just being incompatible with the 1969 North Sea container shelf cases. And one more thing, one more question. We can apply the same approach to the delimitation of the container shelf within and beyond 200 nautical miles. Yes, but just even though we take the same approach, is there any unique relevant circumstances about the delimitation of the container shelf beyond 200 nautical miles? Because yes, the ICLS and the ICJ touched the delimitation of the container shelf beyond 200 nautical miles for last 10 years. However, the direction of the delimitation line has not changed. So just my question is there any unique, any independent, relevant circumstance for the delimitation of the container shelf beyond 200 nautical miles? Actually, we have a few time, little time to discuss about all the things regarding maritime delimitation. But I think just taking two professors' excellent presentations, we can cover the rules and the delimitation of the between entitlement claim and right. A very good point. And then just for the last 10 years, because of the cross-reference of the important statements decided by each other, the ICJ and the ICLS, because we have almost, I agree, Professor Minion's theme, we have almost aqueous judiciary, and then we can focus on the normativity, some elements noted by international courts and tribunals, because the rule in itself is vague, abstract. However, we can focus on the normativity, some points mentioned by international courts and tribunals. But still, I'm a real supporter about the concept of flexibility. So I generally relied on relevant circumstances. Thank you very much for your excellent presentation and comments. Thank you.
Thank you very much, Professor Lee. The panelists have given us much food for thought, and I think it is probably time to give some thought to food. So thank you very much again, and the second session of this conference comes to an end and the meeting rises.
Thank you, Judge AL-KHASAWNEH, for moderating a session, and thank you for all the speakers for their insights and experience. Ladies and gentlemen, please give a big round of applause for the moderator and all our speakers.